This is an AZCourtHelp Legal Talk on how to apply for an order of protection in Arizona. I'm your presenter, Kay Radwanski, Domestic Violence Court Specialist with the Arizona Supreme Court. And today we're going to talk about how to apply for an order of protection in Arizona. And this is information only. This is not legal advice. If you need legal advice, you need to contact an attorney who's licensed to practice law in Arizona. And if you go to AZ Court Help, you'll find a link to legal aid resources if you feel that you don't have sufficient income to hire a private attorney. So please consult AZ Court Help for that additional information. And before we get into a standard order of protection, please know that if you are in immediate danger, call 911. It's really important that if there's a situation going on that warrants police intervention, you need to call them before you think about going to court to get an order of protection. Law enforcement can actually help you get an emergency order of protection when the courts are closed. An officer can contact an on-call judge to get you an emergency order. An emergency order of protection lasts for 7 calendar days after it's been issued. Law enforcement will find the defendant if the defendant has left the scene and serve that person with the emergency order, and they should also provide a copy to you. So if an officer hasn't done that, please be sure to ask for a copy of that emergency order. Another phone number that you should keep handy is the National Domestic Violence Hotline. If you need to talk to a victim advocate about safety or about your situation, the National Domestic Violence Hotline is open 24/7. You can call them, you can chat with them, you can text with them. In Arizona, the Arizona Coalition to End Sexual and Domestic Violence has a helpline that's open during weekday hours. The coalition is a statewide group that can direct you to resources around the state, can provide various services to you or direct you to those services, but more immediately can talk to you about the situation you're in and some steps that you might want to take. For example, an advocate can help you make a safety plan. You will hear me go on and on during this presentation about the importance of a safety plan. Whether or not you have an order of protection, if you're in a domestic violence situation, you really, really, really need to have a safety plan to protect yourself, to protect your children. An advocate can explain to you how an order of protection will be served on the defendant. The process changed in our law a couple years ago, so I'll explain a little more in detail later, but an order of protection is going to leave the court very quickly for service on the defendant. So you need to understand what that process looks like. An advocate can also help you understand the court process, because even if you're talking about an ex parte order of protection, you're going to have to go in front of a judge, whether that's by video, by telephone, or in person in a courtroom. And an advocate can explain to you what that ex parte hearing will look like and what you should expect in that sort of court event. An advocate can help you navigate AZPoint. We're going to talk more in detail about AZPoint, but it's a web-based system that you can use to fill out your paperwork for an order of protection. An advocate can help review your petition with you. The petition is a very important document in the court proceeding, and it's important to make sure that the allegations that you write in there are clear so the judge understands what happens to you. It's always helpful to tell your story to another person so they can ask you questions or just so you can share that information with somebody else to get it clear in your mind before you put your pen to your paper. An advocate can also connect you to services in your area. There are shelters, various support groups and programs and things like that. So an advocate in your area knows what's available in that space. And they can talk to you about technology and safety. In today's world, we have smartphones, we have cameras all over the place, we have doorbells with cameras and things like that. And when you're in a domestic violence situation, it's important to know what the other person in your relationship knows about what you have, where you are. Your phone can be used to track your location,
GPS devices can be planted on cars. If you have a doorbell system that's got remote access, somebody could lock you in or out of your house. So an advocate can talk to you about all those various types of technology that might be part of your life and how you can manage those safely. Again, we're talking about safety plans. Why is a safety plan important? An order of protection can be served quickly. It could be served the same day the court issues it, and you need to be prepared for that. Sometimes service of an order of protection can heighten your risk. It can make the situation more dangerous when the offender realizes that you're trying to get out of the situation. You need to keep your guard up even after your order of protection has been served on the defendant, because you can't put so much reliance on this piece of paper that you stop looking over your shoulder. You have to be aware all the time. And you need to have a safety plan even if you decide an order of protection isn't the thing for you right now. You need that if you're in a domestic violence situation. You always have to have your radar up. It's just really so important. Sometimes people underestimate their risk. My Plan is a free confidential app that was designed by Jacqueline Campbell and others who have done excessive work, outstanding work in risk assessment for victims of domestic violence. So if you have access to a computer or a smartphone, you can access this app and evaluate your own risk based on the factors in your life. Okay, let's get down to the nitty-gritty of how to apply for an order of protection. There's a web-based system called AZPoint, and the link to that is located throughout this PowerPoint. AZPoint is an internet-based application. You can access it from anywhere as long as you can access the internet. So if you have a device at home, you could use AZPoint at home and then contact a court, and we'll go into those steps a little bit later. Some of the courts have public computers or kiosks that are available where you can use AZPoint. So you can also use the automated system at a court. If you're uncomfortable with the technology or it's just not available where you are, you can file paperwork at a court, and we'll talk about that as well. There's no fee to file a petition for a protective order, whether it's an order of protection, an injunction against harassment, or an injunction against workplace harassment. There's also no fee to have an order of protection served. If you do file on paper at a court, the court is going to ask you to fill out various pieces of paper. The first form that you will be given is a plaintiff's guide sheet. This doesn't actually have anything that you need to fill out, but this form has lots of information about orders of protection and the two types of injunctions, and lots of information that you need to read before you file for the order of protection, if it's at all possible to read it ahead of time. These documents are also contained in AZPoint, so you can find that information there as well. The next form that you'll be asked to fill out is the plaintiff's information sheet. This is a confidential form. This is the form that contains your address and your email address, if you have one, your telephone numbers. It also has information about the defendant, their address, phone number, contact information, that sort of thing. This form is confidential, and the court will not include this in any kind of public records requests. So please be assured that your confidential information will be kept confidential, and your residential address is also confidential by statute. The next form that you'll be asked to fill out is the petition. This is where you give some basic information about who you are, who you want protected, what you're asking the court to do. But even more important on this form is where you write down the allegations, the things that you are telling the court that the other person, the defendant, did to you. And lastly, there's another form, the Service of Process Information form, that the court will provide. This is not necessarily information that the court needs, but this is information that will help law enforcement find the defendant and serve your order of protection. This form too is confidential. Law enforcement is aware that they're not to give a copy of this to the defendant. This will ask for additional information if you know this information about where the defendant can be found. For example, what are the defendant's work hours? What is the defendant's day off from work? Are there places that the defendant goes to outside of work or home, regularly? Maybe they go to a club or a bar or something like that on every Thursday night at 7 o'clock for some reason. So this information on this form will really help law enforcement in their quest to find the defendant and serve the order of protection. Let's talk now about AZPoint. This is the Arizona Protective Order Initiation and Notification Tool. This is a web-based system, as I said, and it launched on January 1st of 2020. So it's been in operation for about 2.5 years now. In looking at some statistics, we see that about 2/3 of the people who are applying for orders of protection are using AZPoint, and about 1/3 are filing on paper. AZPoint is a public web portal. If you can get to the internet from anywhere, you can get to AZPoint. There's no fee to use AZPoint, and you can use it from all sorts of devices, smartphones, laptops, tablets, computers. And as I previously mentioned, some courts have a public kiosk where you can also use AZPoint. AZPoint doesn't present you with the forms that I showed you. What it does is a guided interview that asks you questions. For example, what is your name? When you type in your name, it fills in all the forms where your name needs to be shown. So you don't have to answer or write in the same answers over and over again. It has a hover help feature. So if there's a question that has some additional explanation, maybe the question is more complicated than you think, you can scroll over the hover help and see information about that particular question. There are FAQs built into the system, including the plaintiff's guide sheet, to help give you information about questions you may have. When you use AZPoint, your petition is stored in the cloud for 90 days while you work on it. And that's a great time to talk to an advocate if you don't have an immediate urgency to get your order of protection, but it's something that you're thinking about, something you want to be prepared for. You can create as many petitions as you like in AZPoint. However, if you're intending to file against one person, you can keep going back to that same petition, adding information, changing information up until the time you're ready to file that with a court. So we highly recommend that you use that time if there's no immediate need to talk to an advocate, develop that safety plan, and be prepared for the events that will happen after that. You can use AZPoint to prepare a petition for an order of protection, an injunction against harassment, and an injunction against workplace harassment. We use the same general form for all 3 types of protective orders, so that's what's built into AZPoint as well. When you go to AZPoint, the first thing you'll need to do is create an account. And you can see there's an arrow indicating to create an account. So you do that first because you need to establish your account. There are various pieces in preparing your account, but some of the features I want to highlight as far as AZPoint. First, there's a safety button. It's really important to know that this safety button is there. It floats on every screen that you'll be using. If you're working on a computer or a device and you're still in the same location as the person that you're filing against, you can use that safety button to quickly get out of the application if that person comes into the room while you're working on the computer. So it will take you out of the application and off to a Google recipe page or something like that. But it's important to understand it doesn't wipe your computer history. So there's information on AZPoint that will explain to you how you can be on the internet incognito and use safe browsing options so that you stay safe while you're using the computer. If you have technical issues with AZPoint, here's the phone number for the Arizona Courts Support Center. And it's open Monday through Friday from 7 a.m. to 6 p.m. if you need technical support. The steps to creating an account include having an email address. It's important to have an email address so we can confirm that you are who you are. If the person you're filing against has access to your email account or knows the password to your email account, you may want to get a new email address. And there are instructions in AZPoint that help guide you to that. For example, if you have a Gmail address and the other person knows that address and password, you may want to get a Yahoo or a Hotmail, or there are various options out there for different email addresses. And you'll find information on that process on AZPoint. You need to make up a username that has only letters and numbers. You can't add any special symbols to that because the system just doesn't understand those. So use a username with letters and numbers. Create a strong password to your account and keep it private. There's also a way to set up a security question if you need to access that to get your account unlocked. And then more importantly, there's a box that you need to check to acknowledge that when you do file your petition, that your name will appear as an electronic signature and that it's part of the petition, and that you understand by clicking that and filing this with the court, you understand that your petition is truthful. Before you can use your account for the first time, you'll need to check your email for a link to validate your new account. So be sure you have access to your phone or computer, whatever, so you can get that confirmation email so you can get started. When you do go into AZPoint, you'll be able to view petitions that you've already started, or you can start a brand new petition. And there are tabs across the top that will help guide you to the various places where you need to put information. The plaintiff information is the information about you, how the court can contact you, what your address is, and that sort of thing. The defendant information is much more extensive. You'll be asked a lot more questions about the defendant. Some of the questions, you may have to make your best guess. For example, defendant's height, defendant's weight. Even if you don't know the exact date of birth, we need you to make your best guess as to the defendant's birth date, and there's a box to check if you're making that guess. If you and the defendant are already involved in a family court matter, we'll ask you questions about that. It's helpful to have the case number of your family court case, and you need to know the court where that case is pending, because except for that situation, you can file this petition in any superior court, justice court, or city court in Arizona. But if you have a family court case already moving through the courts, you need to file your petition for your order of protection in that superior court. We'll ask about other protective order cases that you and the defendant may have been engaged in the past or currently. There can be cross orders. A person could file a petition for an order of protection against you, and in turn, you could file a petition for an order of protection against that person if you have a legal basis for doing so. The judge cannot issue one order that prohibits each of you from going near each other, but the judge can issue separate orders. So if there is a past history of domestic violence, a past history of orders of protection, please be sure to include that information under protective orders. You can add other people. You can ask the judge to include other people, and it will be up to the judge whether it's appropriate for those people to be added, but there's space on the form where you can be asked about that. And really important is the incident history. We'll talk a little bit more about that, but this is where you tell the judge what happened and why you think you need this protective order. Under the Actions tab, there are options to review your documents and print your documents when you're finished, and you'll reach a state where you're considered court ready when you've included enough information, basic information, to get this petition filed. To get an order of protection, you and the defendant need to have a specific type of relationship. If you and the defendant don't have one of these relationships, you might be eligible for an injunction against harassment. But if you are married now or in the past to the defendant, you and the defendant are household residents now in the past, this does not mean that you have to have an intimate relationship with this person. This can apply to a roommate who lives in the same household as you, a family member, or somebody like that. If you and the defendant have a child in common, then you can apply for an order of protection. one party is pregnant by the other, or the parties are related by blood or marriage. Relatives are limited to parents, grandparents, children, adult children, that sort of thing, in-laws and step in those relationships. Your aunts, uncles, and cousins, while they might be related to you, don't qualify you for an order of protection. If you needed a protective order against an aunt, uncle, or cousin, you could apply for an injunction against harassment unless they fit into one of these groups like a household resident. There's a provision for child victims, and then there's romantic or sexual relationship, which is more commonly known as dating. So you can apply for an order of protection in that situation as well. If you're using AZPoint, you can sign up for notifications from the system. We suggest that you make sure it's appropriate for you to receive emails from a court system. So if this is an email address that's compromised that the defendant might have access to, this again is an opportunity to use a different email address. Or if you have a trusted friend and relative that you would like to receive the notifications on your behalf, you could put that email address here. This is good information to discuss with an advocate about whether you want to receive emails from the system, and if so, whose email address do you want to put there? Here's the part of the petition where we talk about the incidents, what happened and why you need an order of protection. If you're filing on paper, you're going to see the form at the right side of the screen where you tell the judge what happened. We need an approximate date, a month and a year when the incident happened. The judge will be looking back at incidents that happened in the year preceding the filing of this, which means yesterday and backwards for 1 year. So if there's a good reason to consider time outside of a year, you need to explain to the judge why that would be. Perhaps somebody's been incarcerated or has been overseas in the military or something like that and has been out of the country for a while. You want to explain why you need the judge to think about things that happened more than a year ago. If you're using AZPoint, you'll see a screen that's similar to what you're seeing on the left, where you type in the date of the incident. There's a box to check if it's an estimated date, and then you describe what happened. You can include up to 10 different incidents in the AZPoint application. If you're using a paper petition, the form has space for 5, but if you need more paper, just ask the court to hand that to you, and they'll be happy to do that. The petition is a really important part of the filing. By signing it, whether you're doing that with an electronic signature or you're signing it with a pen on a piece of paper, the plaintiff is swearing or affirming under penalty of perjury that the allegations are true, and that's to the best of that person's knowledge. So this is a really important piece of the petition. This is a really important time when you could talk to an advocate, tell them your story, make sure it's clear in your head before you write all of this down. It's extra important to understand that the defendant will receive a copy of this petition when they're served with the order of protection if the judge grants your petition. So whatever you say here is not going to be kept secret from the defendant. They will get a copy of this form. This form isn't a public record until the court receives proof of service that it has been served on the defendant, but once the defendant has been served, it will be open to the public. However, it's not published on public access websites. If a person wanted to look at your case file, they would actually have to come to the court and ask to see that. And the documents that I mentioned early on, the plaintiff's information sheet and the service of process information form, will not be shared with the public. It's also important to understand that if the judge issues your order and it's served on the defendant can ask for a contested hearing at any time while the order's in effect. So that could happen a week after the order is served. It could happen months later. So you need to be prepared for that, because that means at a contested hearing, you have to prove the allegations that you wrote in your petition by a preponderance of the evidence. That means more likely than not. So you need to To be truthful, you need to be prepared. Getting an ex parte order protection may not be the end of the process for you. On an order of protection, a judge can grant various types of relief. The judge can order the defendant not to commit any domestic violence offenses against you or other people who are protected by your order of protection. The judge can grant you exclusive use of a residence that is shared with the defendant. If the plaintiff and the defendant live in separate households, the judge is not going to grant that because the defendant doesn't live with you. But if there's a shared household, the judge can grant exclusive use to the plaintiff. The judge can tell the defendant to stay away from people who are listed on the order and from places that are listed on the order, in addition to a residence that can include a school or a workplace, a daycare center, whatever the plaintiff requests. An order of protection can also protect animals in addition to people. One of the signs of domestic violence is cruelty to animals, and sometimes a person will threaten to harm an animal rather than threaten to harm the victim because they don't want to leave any marks on the victim, but it's easier to harm the animal. So if there's a risk of harm to animals, the plaintiff can ask the judge to protect those animals. And finally, the court can order the defendant not to possess firearms for the duration of the order of protection if there is a credible threat that the defendant will harm the plaintiff or other protected person. If you're thinking about asking the judge to prohibit firearms, you need to discuss with an advocate what information is needed there to make a credible threat. You know, it depends on what happens in your experience, but the judge will be looking for factors, for parts of your story that would support prohibiting somebody from possessing firearms, including a child. If you want to include a child who is not the defendant's child, the defendant has no legal relationship to the child can be included as part of protecting the plaintiff. But if the child is the defendant's biological or legal child, then certain other information is needed by the court before the judge can include the child. So there has to be reasonable cause to believe that physical harm has resulted to the child or may result to the child, or the alleged acts of domestic violence involve the child. Again, you may want to talk to a legal advocate about what alleged acts of domestic violence involve the child means, or if domestic violence may result to the child. It's important to talk that through with somebody else. When you've completed all of the forms or you've worked your way through AZPoint, in AZPoint, you'll get a petition confirmation number. So here you can see the petition confirmation number is number 191. And the system is telling me that the petition I put in here is court ready. So I've provided enough information to be able to file this with an Arizona court. A person can file the petition at a superior court, a justice of the peace court, or a superior court. Again, if there's a pending family law case, a person would need to file it in the family court or in the superior court where the family court case is pending. You can contact the court. I recommend that you contact the court before you file to find out if there are protocols. Since the COVID pandemic, we've had some presumptive hearings that can occur remotely by video or telephone. So a lot of the protective order hearings are being conducted that way. But the judge has some discretion, may require you to come in person. So there's contact information in the AZPoint app that will help you locate various courts around the state. We suggest you contact one of those courts before you file or before you get ready to file, so you can know whether you can appear by video or telephone or some other method. Or if you want to, just go on down to the courthouse near you where you want to file and tell them you're ready to file or ask for the paperwork to go forward. Your identification is not required to file a petition for a protective order. You can't be turned away because you don't have a valid government issued ID card. The judge, the judicial officer will ascertain your identification through your sworn testimony, because you will have an ex parte hearing with the judge and you will have to swear or affirm to tell the truth. Your immigration status is also not considered. The court is not going to ask you about your immigration status. Again, the plaintiff's address and contact information is confidential by statute, and it's on the form that's marked confidential. So be assured that's not going to be shared. Now we get to the ex parte hearing. This is an ex parte hearing is one where only one party is present. This is not a common occurrence in a court. Usually in a courtroom, both parties, plaintiff and defendant, respondent and petitioner, both need to be there. But this is an occasion when only one party is there. The defendant is not invited to the ex parte hearing. For the judge to decide whether to issue your order of protection, the judge has to find reasonable cause to believe that domestic violence has occurred or domestic violence may occur. So the judge will be looking first to ensure that the plaintiff and the defendant have one of the statutory relationships that we talked about a little bit earlier. And the judge will be looking through the allegations to determine whether an act of domestic violence has occurred. If the judge sees one of those acts that are specified in the law and sees that there's a protective order or an order protection relationship, the judge will have a legal basis to issue the order of protection. The judge's options are to deny the petition, to set a pre-issuance hearing, which is akin to a contested hearing, or grant the petition. If the judge denies the petition, it's important to understand that there's no limit on the number of times a plaintiff can ask for a protective order. There's no limit on the times a person can dismiss an order of protection. And it's important to understand that the judge will not consider these past dismissals or denials in considering a new petition if a person needed to file one. Every petition that's filed in an order of protection has to be considered on its own merits. A pre-issuance hearing, as I said, is like a contested hearing. The court will notify the defendant, will provide a copy of the petition to the defendant, and will conduct a hearing within 10 days. At a contested hearing, the plaintiff has to prove the allegations by a preponderance of the evidence, more likely than not. The defendant may or may not have an attorney. The court does not appoint attorneys for anybody in civil cases, but it's important to know that the defendant could turn up with an attorney. If you are concerned about that, it's a good idea to contact an attorney and get legal advice for yourself. If your petition is granted and the judge issues an order of protection, once a judge grants an order of protection, what will happen next is that the court will assign the order of protection to a law enforcement agency or a constable for service on the defendant. It flows through the automated system, and an algorithm is applied that will look at the type of court that issued the order of protection and the defendant's zip code, and that's how service will be assigned. So if a law enforcement agency, let's say Phoenix Police Department, receives your order of protection for service, it will pop up on their dashboard. They'll see the petition and the order of protection because they have to serve both of those documents on the defendant. And they will do their best to find the defendant as quickly as they can. They can use AZPoint at their end once they've served the defendant to enter the declaration of service, telling the court where and when the defendant was served at what time, and that will flow back through the system to the court. That information also goes to the National Crime Information Center, so law enforcement anywhere in the United States will be able to see that order of protection once it has been served. The court will also give you copies of the order of protection. The court usually gives at least 2 copies. It's a good idea, and advocates will tell you that it's really important for you to keep a copy of your order of protection on you at all times. You may want to think about whether you should share that with friends or family that you can trust. whether it's necessary for a child's daycare center to receive a copy, if the defendant is to stay away from children, if you need to share that with a school. That's good information to ask an advocate. Once an order of protection has been served on the defendant, it's valid and enforceable, and the defendant can be arrested for violating the order of protection. Again, another reason for keeping a copy with you is that if the defendant comes near you before law enforcement has found that person and served them, you can call 911 and law enforcement can use your copy of the order of protection to serve the defendant. If you call the defendant after service, law enforcement won't do anything to you because the order is effective only against the defendant. But it's not a good idea to contact the defendant because it undermines your credibility with the court as far as whether you think you're in danger. So you can't change this order on your own. Let's say, for example, you and the defendant reconcile and there's still an active order of protection out there. The defendant can still be arrested for violating that order. So consider that, talk to an attorney about that. Here's where you can get some more information about domestic violence and orders of protection. AZCourtHelp.org is a fabulous website where you can find all sorts of information. It will direct you to various resources. AZCourts.gov, we have a tab for domestic violence information that has a lot of resources, links to safety plans, links to local advocates, that sort of thing. And then we have a lot of information on AZPoint. So that's at azpoint.azcourts.gov. So that's the end of my presentation. Thank you, Sarah.